to turn to that issue, the role of the President's lawyer, his private counsel, in this proceeding. I would like to yield my time, Mr. Chief Justice, to Jane Serene Raskin.
Mr. Chief Justice, Majority Leader McConnell, members of the Senate, I expect you have heard American poet Carl Sandburg's summary of the trial lawyer's dilemma. If the facts are against you, argue the law. If the law is against you, argue the facts. If the facts and the law are against you, pound the table and yell like hell. Well, we've heard the House managers do some table pounding and a little yelling. But in the main, they've used a different tactic here, a tactic familiar to trial lawyers, though not mentioned by Mr. Sandburg. If both the law and the facts are against you, present a distraction. Emphasize a sensational fact, or perhaps a colorful and controversial public figure who appears on the scene. Then distort certain facts, ignore others, even when they're the most probative, make conclusory statements, and insinuate the shiny object is far more important than the actual facts allow. In short, divert attention from the holes in your case. Rudy Giuliani is the House manager's colorful distraction. He's a household name, legendary federal prosecutor who took down the mafia, corrupt public officials, Wall Street racketeers, crime-busting mayor who cleaned up New York and turned it around, a national hero, America's mayor after 9/11, and after that, an internationally recognized expert on fighting corruption. To be sure, Mr. Giuliani has always been somewhat of a controversial figure for his hard-hitting, take-no-prisoner approach. But it's no stretch to say that he was respected by friend and foe alike for his intellect, his tenacity, his accomplishments, and his fierce loyalty to his causes and his country. And then, the unthinkable. He publicly supported the candidacy of President Trump, the one who was not supposed to win. And then, in the spring of 2018, he stood up to defend the president, successfully it turns out, against what we all now know as the real debunked conspiracy theory, that the Trump campaign colluded with Russia during the 2016 campaign. The House managers would have you believe that Mr. Giuliani is at the center of this controversy. They've anointed him the proxy villain of the tale, the leader of a rogue operation. Their presentations were filled with ad hominem attacks and name-calling. Cold-blooded political operative, political bagman. But I suggest to you that he's front and center in their narrative for one reason and one reason alone: to distract from the fact that the evidence does not support their claims. So what's the first tell that Mr. Giuliani's role in this may not be all that it's cracked up to be? They didn't subpoena him to testify. In fact, Mr. Schiff and his committee never even invited him to testify. They took a stab at subpoenaing his documents back in September, and when his lawyer responded with legal defenses to the production, the House walked away. But if Rudy Giuliani is everything they say he is, don't you think they would have subpoenaed and pursued his testimony? Ask yourselves, why didn't they? In fact, it appears the House committee wasn't particularly interested in presenting you with any direct evidence of what Mayor Giuliani did or why he did it. Instead, they ask you to rely on hearsay, speculation, and assumption, evidence that would be inadmissible in any court. For example, the House managers suggest that Mr. Giuliani, at the President's direction, demanded that Ukraine announce an investigation of the Bidens and Burisma before agreeing to a White House visit. They base that on a statement to that effect by Ambassador Sondland. But what the House managers don't tell you was that Sondland admitted he was speculating about that. He presumed that Mr. Giuliani's requests were intended as a condition for a White House visit. Even worse, his assumption was on third-hand information. As he put it, the most he could do is repeat what he heard through Ambassador Volker from Giuliani, whom he presumed spoke to the president on the issue. And by the way, as Mr. Purpura has explained, the person who was actually speaking to Mr. Giuliani, Ambassador Volker, testified clearly that there was no linkage between the meeting with President Solinsky and Ukrainian investigations. The House managers also make much of a May 23rd White House meeting during which the President suggested to his Ukraine working group, including Ambassadors Volker and Sondland, that they should talk to Rudy. The managers told you that President Trump gave a directive and a demand that the group needed to work with Giuliani if they wanted him to agree with the Ukraine policy they were proposing. But those words, directive and demand, are misleading. They misrepresent what the witnesses actually said. Ambassador Volker testified that he understood, based on the meeting, that Giuliani was only one of several sources of information for the president. And the president simply wanted officials to speak to Mr. Giuliani because he knows all these things about Ukraine. As Volker put it, the president's comment was not an instruction, but just a comment. Ambassador Sondland agreed. He testified that he didn't take it as an order, and he added that the president wasn't even specific about what he wanted us to talk to Giuliani about. So, it may come as no surprise to you that after the May 23rd meeting, the one during which the House managers told you the president demanded that his Ukraine team talk to Giuliani, neither Volker nor Sondland even followed up with Mr. Giuliani until July. And the July follow-up by Mr. Volker happened only because the Ukrainian government asked to be put in touch with him. Volker testified that President Zelensky's senior aide, Andriy Yermak, approached him to ask to be connected to Mr. Giuliani. House Democrats also rely on testimony that Mayor Giuliani told Ambassadors Volker and Sondland that, in his view, to be credible, a Ukrainian statement on anti-corruption should specifically mention investigations into 2016 election interference and Burisma. But when Ambassador Volker was asked whether he knew if Giuliani was, and these are his words, conveying messages that President Trump wanted conveyed to the Ukrainians, Volker said that he did not have that impression. And he believed that Giuliani was doing his own communication about what he believed he was interested in. But even more significant than their reliance on presumptions, assumptions, and unsupported conclusions is the manager's failure to place in any fair context Mr. Giuliani's actual role in exploring Ukrainian corruption. To hear their presentation, you might think that Mayor Giuliani had parachuted into the president's orbit in the spring of 2019 for the express purpose of carrying out a political hit job. They'd have you believe that Mayor Giuliani was only there to dig up dirt against former Vice President Biden because he might be President Trump's rival in the 2020 election. Of course, Mr. Giuliani's intent is no small matter here. It's a central and essential premise of the House manager's case that Mr. Giuliani's motive in investigating Ukrainian corruption and interference in the 2016 election was an entirely political one, undertaken at the president's direction. But what evidence have the managers actually offered you to support that proposition? On close inspection, it turns out, virtually none. They just say it over and over and over. And they offer you another false dichotomy. Either Mr. Giuliani was acting in an official capacity to further the president's foreign policy objectives, or he was acting as the president's personal attorney, in which case they conclude, ipsy dixit, his motive could only be to further the president's political objectives. The House managers then point to various of Mr. Giuliani's public statements in which he is clear and completely transparent about the fact that he is indeed the president's personal attorney. There you have it. Giuliani admits he's acting as the president's personal attorney, and therefore he had to have been acting with a political motive to influence the 2020 election. No other option, right? Wrong. There is, of course, another obvious answer to the question, what motivated Mayor Giuliani to investigate the possible involvement of Ukrainians in the 2016 election? The House managers know what the answer is. It's in plain sight. And Mr. Giuliani has told any number of news outlets exactly when and why he became interested in the issue. It had nothing to do with the 2020 election. Mayor Giuliani began investigating Ukraine corruption and interference in the 2020 election way back in November of 2018, a full 6 months before Vice President Biden announced his candidacy, and 4 months before the release of the Mueller report, when the biggest false conspiracy theory in circulation, that the Trump campaign had colluded with Russia during the 2016 campaign, was still in wide circulation. As The Hill reported, as President Trump's highest-profile defense attorney, the former New York City mayor, often known simply as Rudy, believed the Ukrainians' evidence could assist in his defense against the Russian collusion investigation and former special counsel Robert Mueller's final report. So Giuliani began to check things out in late 2018 and early 2019. The genesis of Mayor Giuliani's investigation was also reported by numerous other media outlets, including CNN, which related that Giuliani's role in Ukraine can be traced back to November 2018, when he was contacted by someone he describes as a well-known investigator. The Washington Post and many other news outlets reported the same information. So yes, Mayor Giuliani was President Trump's personal attorney, but he was not on a political errand. As he has stated repeatedly and publicly, he was doing what good defense attorneys do. He was following a lead from a well-known private investigator. He was gathering evidence regarding Ukrainian election interference to defend his client against the false allegations being investigated by Special Counsel Mueller. But the House managers didn't even allude to that possibility. Instead, they just repeated their mantra that Giuliani's motive was purely political. And that speaks volumes about the bias with which they have approached their mission. The bottom line is, Mr. Giuliani defended President Trump vigorously, relentlessly, and publicly throughout the Mueller investigation, and in the nonstop congressional investigations that followed, including the attempted Mueller redo by the House Judiciary Committee, which the managers would apparently like to sneak in the back door here. The House managers may not like his style. You may not like his style. But one might argue that he is everything Clarence Darrow said a defense lawyer must be: outrageous, irreverent, blasphemous, a rogue, a renegade. Fact is, in the end, after a 2-year siege on the presidency, 2 Inspector General reports, and a $32 million special counsel investigation, turns out Rudy was spot on. Seems to me, if we're keeping score, on who got it right, on allegations of FISA abuse, egregious misconduct at the highest level of the FBI, alleged collusion between the Trump campaign and Russia, and supposed obstruction of justice in connection with the special counsel investigation. The score is Mayor Giuliani 4, Mr. Schiff 0. But in this trial, in this moment, Mr. Giuliani is just a minor player, that shiny object designed to distract you. Senators, I urge you most respectfully, do not be distracted. Thank you, Mr. Chief Justice. I yield back to Mr. Sekulow.
Mr. Chief Justice, members of the Senate, House managers, we're going to now move to a section dealing with the law. Two issues in particular that my colleague, Pat Philbin, the Deputy White House Counsel, will be addressing. Issues involving due process and issues, specifically legal issues, dealing with the second article of impeachment, obstruction of Congress. So I will yield my time now, Mr. Chief Justice, to Mr. Philbin.
Mr. Chief Justice, Senators, Majority Leader McConnell, Minority Leader Schumer, the other day as we opened our presentation, I touched on two areas, some of the due process violations that characterized the proceedings in the House, and some of the fundamental mischaracterizations and errors that underpin the House Democrats' charge of obstruction. And today I'll complete the presentation on those points to round out some of the fundamentally unfair procedure that was used in the House and its implications for this proceeding before you now, and also address in detail the purported charges of obstruction in the second article of impeachment. On due process, there are three fundamental errors that infected the proceedings in the House. The first is, as I explained on Saturday, the impeachment inquiry was unauthorized and unconstitutional from the beginning. No committee of the House has the power to launch an inquiry under the House's impeachment power unless the House itself has taken a vote to give that authority to a committee. I noted that in cases such as Rumley versus United States and United States versus Watkins, the Supreme Court has set out these principles, general principles derived from the Constitution, which assigns authority to each chamber of the legislative branch, to the House and to the Senate, but not to individual members or to subcommittees. For an authority of the House to be transferred to a committee, the House has to vote on that. The D.C. Circuit has distilled the principles from those cases this way. To issue a valid subpoena, a committee or subcommittee must conform strictly to the resolution establishing its investigatory powers. That was the problem here. There was no such resolution. There was no vote from the House authorizing the issuance of subpoenas under the impeachment power. So this inquiry began with nearly 24 invalid subpoenas. The Speaker had the House proceed on nothing more than a press conference in which she purported to authorize committees to begin an impeachment power. Under the Constitution, she lacked that authority. As the chairman of the House Judiciary Committee during the Nixon impeachment inquiry pointed out, Peter Rodino explained that such a resolution from the House has always been passed by the House. It is a necessary step if we are to meet our obligations. So we began this process with unauthorized subpoenas that impose no compulsion on the executive branch to respond with documents or witnesses. And I'll be coming back to that point, that threshold foundational point, when we get to the obstruction charge. The second fundamental due process error is that the House Democrats denied the President basic due process required by the Constitution and by fundamental principles of fairness in the procedures that they used for the hearings. And I'm not going to go back in detail over those. As we heard from Judge Starr, the House Democrats essentially abandoned the principles that have governed impeachment inquiries in the House for over 150 years. And I'll touch on just a few points and respond to a couple of points that the House managers have made. The first is that in denying due process rights, the House proceedings were a huge reversal from the positions House Democrats themselves have taken in the recent past, particularly in the Clinton impeachment proceeding. And I believe we have Manager Nadler's description of what was required. Manager Nadler was explaining that due process requires at a minimum notice of the charges against you, the right to be represented by counsel, the right to cross-examine witnesses against you, and the right to present evidence. All of those rights were denied to the President. Now, one of the responses that the managers have made to the defect that we pointed out in the secret proceedings, where Manager Schiff began these hearings in the basement bunker, is that, well, that was really just best investigative practice. They were operating like a grand jury. Don't be fooled by that. Those hearings operated nothing like a grand jury. A grand jury has secrecy primarily for two reasons: to protect the direction of the investigation so others won't know what witnesses are being called in and what they're saying, to keep that secret for the prosecutor to be able to keep developing the evidence, and to protect the accused, because the accused might not ever be indicted. In this case, all of that information was made public every day. The House Democrats destroyed any analogy, any legitimate analogy to a grand jury, because that was all public. They made no secret that the President was the target. They issued vile calumnies about him every day. And they didn't keep the direction of their investigation secret. Their witness lists were published daily. The direction of the investigation was open, and the testimony that took place was selectively leaked to a compliant media to establish a false narrative about the President. If that sort of conduct had occurred in a real grand jury, that would have been a criminal violation. Prosecutors can't do that. Under Rule 6E of the federal criminal rules, it's a criminal offense to be leaking what takes place in a grand jury. And also, the grand jury explanation provides no rationale whatsoever for the second round of hearings. Remember, after the basement bunker, after the secret hearings where the testimony was pre-screened, then the same witnesses who had already been deposed were put on in a public hearing where the President was still excluded. Ask yourself, what was the reason for that? In every prior presidential impeachment in the modern era where there have been public hearings, the President has been represented by counsel and could cross-examine witnesses. Why did there have to be public televised hearings where the President was excluded? That was nothing more than a show trial. Now, I also addressed the other day the House manager's contention that they had offered the President due process, that when things reached the third round of hearings in front of the House Judiciary Committee, that Manager Nadler offered the President due process, and I explained why that was illusory. There was no genuine offer there, because before any hearings began, other than the law professor's seminar on December 4th, the Speaker had already determined the outcome, already said there were going to be articles of impeachment, and the Judiciary Committee had informed the counsel's office that they had no plans to call any fact witnesses or have any factual hearings whatsoever. It was all done, it was locked in, it was baked. And there was something else hanging over that when they had offered, purportedly, to allow the President some due process rights, and that was a special provision in the rules for the House Judiciary Committee proceedings, also unprecedented, that allowed the House Judiciary Committee to deny the President any due process rights at all if he continued to refuse to turn over documents or not allow witnesses to testify. So that If the president didn't give up his privileges and immunities that he had been asserting over executive branch confidentiality interests, if he didn't comply with what the House Democrats wanted, then it was up to Chairman Adler potentially to say no rights at all. And there's a term for that in the law. It's called an unconstitutional condition. You can't condition someone's exercise of some rights on their surrendering other constitutional rights. You can't say, we'll let you have due process in this way if you waive your constitutional privileges on another issue. The last point I'll make about due process is this. It's important to remember that due process is enshrined in the Bill of Rights for a reason. It's not that process is just an end in itself. Instead, it's a deep-seated belief in our legal tradition that fair process is essential for accurate decision-making. Cross-examination of witnesses in particular is one of the most important procedural protections for any American. The Supreme Court has explained that for over 250 years, our legal tradition has recognized cross-examination as the greatest legal engine ever discovered for the discovery, ever invented for the discovery of truth. So why did House Democrats jettison every precedent and every principle of due process in the way they devised these hearing procedures? Why did they devise a process that kept the president locked out of any hearings for 71 of the 78 days of the so-called investigation? I would submit because their process was never about finding the truth. The process was about achieving a predetermined outcome on a timetable and having it done by Christmas. And that is what they achieved. Now, the third fundamental due process error is that the whole foundation of these proceedings was also tainted beyond repair because an interested fact witness supervised and limited the course of the factual discovery, the course of the hearings. And I explained the other day that Manager Schiff had a reason, potentially, because of his office's contact with the so-called whistleblower and what was discussed and how the complaint was framed, which all remained secret, to limit inquiry into that, which is relevant. The whistleblower began this whole process, his bias, his motive, why he was doing it, what his sources were. That's relevant to understand what generated this whole process. But there was no inquiry into that. So what conclusion does this all lead to, all of these due process errors that have infected the proceeding up to now? I think it's important to recognize the right conclusion is not that this body, this chamber, should try to redo everything, to start bringing in new evidence, bring in witnesses because the president wasn't allowed witnesses below, and redoing the whole process. And that's for a couple of reasons. One is, first, as my colleagues have demonstrated, despite the one-sided unfair process in the House, the record that the House Democrats collected through that process already shows that the president did nothing wrong. It already exonerates the president. But the second and more important reason is because of the institutional implications it would have for this chamber. Whatever precedent is set, whatever this body accepts now as a permissible way to bring an impeachment proceeding and to bring it to this chamber, becomes the new normal. And if the new normal is going to be that there can be an impeachment proceeding in the House that violates due process, that doesn't provide the president or another official being impeached due process rights, that fails to conduct a thorough investigation, that doesn't come here with the facts established, that then this body should become the investigatory body and start redoing what the House didn't do and finding new witnesses and doing things over and getting new evidence, then that's going to be the new normal. And that will be the way that this chamber has to function. And there'll be a lot more impeachments coming because it's a lot easier to do an impeachment if you don't have to follow due process and can come here and expect the Senate to do the work that the House didn't do. I would submit that is not the constitutional function of this chamber sitting as a court of impeachment. And this chamber should not put its imprimatur on a process in the House that would force this chamber to take on that role. Now I'll move on to the charge of obstruction in the second article of impeachment. Accepting that article of impeachment would fundamentally damage the separation of powers under the Constitution by permanently altering the relationship between the executive and the legislative branches. In the second article, House Democrats are trying to impeach the president for resisting legally defective demands for information by asserting established legal defenses and immunities based on legal advice from the Department of Justice's Office of Legal Counsel. In essence, the approach here is that House Democrats are saying, when we demand documents, the executive branch must comply immediately. Any assertions of privilege or defenses to our subpoenas are further evidence of obstruction. We don't have to go through the constitutionally mandated accommodations process to work out an acceptable solution with the executive branch. We don't have to go to the courts to establish the validity of our subpoenas. At one point, Manager Schiff said that anything that makes the House even contemplate litigation is evidence of obstruction. Instead, the House claims they can jump straight to impeachment. What this really means in this case is that they're saying for the president to defend the prerogatives of his office, to defend constitutionally grounded principles of executive branch privileges or immunities, is an impeachable offense. If this chamber accepts that premise, that what has been asserted here constitutes an impeachable offense, it will forever damage the separation of powers. It will undermine the independence of the executive and destroy the balance between the legislative and executive branches that the framers crafted in the Constitution. As Professor Turley testified before the House Judiciary Committee, basing impeachment on this obstruction theory would itself be an abuse of power by Congress. And I'd like to go through that and unpack and explain some of that. And I'll start by outlining what the Trump administration actually did in response to subpoenas, because there are three different actions, three different legally based assertions for resisting different subpoenas that the Trump administration made. And I pointed out on Saturday there has been this constant refrain from the House Democrats that there was just blanket defiance, blanket obstruction, as if it were unexplained obstruction, just we won't cooperate without more. And that's not true. There were very specific legal grounds provided, and each one was supported by an opinion from the Department of Justice's Office of Legal Counsel. So the first is executive branch officials declined to comply with subpoenas that had not been authorized, and that's the point I made at the beginning. There was no vote from the House. Without a vote from the House, the subpoenas that were issued were not authorized. And I pointed out that in an October 18th letter from the White House counsel, that specific ground was explained. And it wasn't just from the White House counsel. There were other letters. On the screen now is an October 15th letter from OMB, which explained, absent a delegation by a House rule or a resolution of the House, none of your committees has been delegated jurisdiction to conduct an investigation pursuant to the impeachment power under Article 1, Section 2 of the Constitution. And the letter went on to explain that legal rationale. Not blanket defiance. There are specific exchanges of letters explaining these legal grounds for resisting. The second ground, the second principle that the Trump administration asserted was that some of these subpoenas purported to require the president's senior advisors, his close advisors, to testify. Following at least 50 years of precedent, the Department of Justice's Office of Legal Counsel advised that 3 senior advisors to the president, the acting White House Chief of Staff, the legal advisor to the National Security Council, and the Deputy National Security Advisor, were absolutely immune from compelled congressional testimony. And based on that advice from the Office of Legal Counsel, the President directed those advisors not to testify. Administrations of both political parties have asserted this immunity since the 1970s. President Obama asserted it as to the Director of Office of Political Strategy and Outreach. President George W. Bush asserted it as to his former counsel and to his White House Chief of Staff. President Clinton asserted it as to two of his counsels. President Reagan asserted it as to his counsel, Fred Fielding, and President Nixon asserted it. This is not something that was just made up recently. There is a decades-long history of the Department of Justice providing the opinion that senior advisors to the President are immune from compelled congressional testimony. And it's the same principle that was asserted here. And there are important rationales behind this immunity. One is that the President's most senior advisors are essentially his alter egos. And allowing Congress to subpoena them and compel them to come testify would be tantamount to allowing Congress to subpoena the President and force him to come testify. But that, under the separation of powers, would not be tolerable. Congress could no more do that with the President than the President could force members of Congress to come to the White House and answer to him. There's also a second and important rationale behind this immunity, and that relates to executive privilege. The immunity protects the same interests that underlie executive privilege. The Supreme Court has recognized executive privilege that protects the confidentiality of communications with the President and deliberations within the executive branch is, as the court put it in United States versus Nixon, the privilege is fundamental to the operation of government and inextricably rooted in the separation of powers under the Constitution. So the Supreme Court has recognized the executive needs this privilege to be able to function. It's rooted in the separation of powers. As Attorney General Janet Reno advised President Clinton, the immunity such advisors enjoy from testimonial compulsion by a congressional committee is absolute and may not be overborne by competing congressional interests. So that's Attorney General Reno and President Clinton. This is not a partisan issue. This is not a Republican or Democrat issue. Administrations of both parties assert this principle of immunity for senior advisors. And why does it matter? It matters because the Supreme Court has explained the fundamental principle behind executive privilege is that it's necessary to have confidentiality in communications and deliberations in order to have good and worthwhile deliberations, in order to have people provide their candid advice to the President. Because if they knew what they were going to say was going to be on the front page of the Washington Post the next day or the next week, they wouldn't tell the President what they actually thought. If you want to have good decision-making, there has to be that zone of confidentiality. And this is the way the Supreme Court put it. Quote, "Human experience teaches that those who expect public dissemination of their remarks may well temper candor with a concern for appearances and for their own interests to the detriment of the decision-making process." End quote. That was also from United States versus Nixon. So those are exactly the interests that are protected by having senior advisors to the President be immune from compelled congressional testimony, because once someone is compelled to sit in the witness seat and start answering questions, it's very hard for them to protect that privilege, to make sure that they don't start revealing something that was discussed. So for a small circle of those close to the President, for the past 40 to 50 years, administrations of both parties have insisted on this principle. Now, the other night, the House managers, when we were here very late last week, they suggested that executive privilege was a distraction, and Manager Nadler called it nonsense. Not at all. It is a principle recognized by the Supreme Court, a constitutional principle grounded in the separation of powers. They also asserted that this immunity has been rejected by every court that has addressed it, as if to make it seem that lots of courts have addressed this. They've all said that this theory just doesn't fly. That's not accurate. That's not true. In fact, in most instances, once the president asserts immunity for a senior advisor, the accommodations process between the executive branch and the legislature begins, and there's usually some compromise to allow perhaps some testimony, not in an open hearing, but in a closed hearing or in a deposition, perhaps to provide some other information instead of live testimony. There's a compromise. But the only two times it's been litigated, district courts, it is true, rejected the immunity. One was in a case involving former counsel to President George W. Bush, Harriet Miers. The district court rejected the immunity, but immediately on appeal, the Court of Appeals for the D.C. Circuit stayed that decision. And that decision means to stay that district court decision, that the appellate court thought there was a likelihood of success on appeal, that the executive branch might succeed, or at a minimum, that the issue of immunity presented questions going to the merits so serious, substantial, difficult, and doubtful as to make them a fair ground for litigation. So the first decision was stayed. The second district court decision is still being litigated right now. It's the McGahn case that the House has brought, trying to get testimony from former counsel to President Trump, Donald McGahn. And that case was just argued in the D.C. Circuit on January 3rd. So there is no established law suggesting that this immunity somehow has been rejected by the courts. It's still being litigated right now. And it is an immunity that is a standard principle asserted by every administration of both parties for the past 40 years. Asserting that principle can't be treated as obstruction of Congress. The third action that the president took, that the administration took, related to the fact that House Democrats' subpoenas tried to shut out executive branch counsel, agency counsel, from the depositions of executive branch employees. Now, the Office of Legal Counsel concluded that congressional committees may not bar agency counsel from assisting an executive branch witness without contravening the legitimate prerogatives of the executive branch, and that attempting to enforce a subpoena while barring agency counsel, quote, would be unconstitutional, unquote. The president relied on that legal advice here. As Judge Starr pointed out, the president was consulting with the Department of Justice, receiving advice from the very respected Office of Legal Counsel, and following that advice about the constitutional prerogatives of his office and the constitutional prerogatives of the executive branch. Again, administrations of both political parties have recognized the important role that agency counsel plays. In the Obama administration, the Office of Legal Counsel stated that exclusion of agency counsel, quote, could potentially undermine the president's constitutional authority to consider and assert executive privilege where appropriate. So why is agency counsel important? As I tried to explain, the executive privilege of confidentiality for communications with the president, for internal deliberative communications of the executive branch, those are important legal rights. They're necessary for the proper functioning of the executive branch. And agency counsel is essential to protect those legal rights. When an individual employee goes in to testify, he or she might not know, probably would not know, where is the line for what's covered by executive privilege or deliberative process privilege, not things that employees necessarily know. And their personal counsel, even if they're permitted to have their personal counsel with them, same thing. Most attorneys for employees don't know the finer points of executive branch confidentiality interests, of deliberative process privilege, and it's also not their job to protect those interests. They're the personal lawyer for the employee who's testifying, trying to protect that employee from potential legal consequences. We usually have lawyers to protect legal rights. So it makes sense when there is an important legal and constitutionally based right at stake, the executive privilege, that there should be a lawyer there to protect that right for the executive branch. And that's the principle that the Office of Legal Counsel endorsed. This also doesn't raise any insurmountable problems for congressional investigations or finding information. In fact, just as recently as April 2019, the House Committee on Oversight and Government Reform reached an accommodation with the Trump administration after the administration had declined to make someone available for a deposition because of the lack of agency counsel. And that issue was worked out, an accommodation was made, and there was some testimony provided in other circumstances. So it doesn't always result in the kind of escalation that was seen here straight to impeachment. The accommodation process can work things out. House Democrats have pointed to a House rule that excludes agency counsel, but of course a House rule cannot override a constitutional privilege. So those are the three principles that the Trump administration asserted. Now I'd like to turn to the claim that somehow this assertion of these principles created an impeachable offense. The idea that asserting defenses and immunities, legal defenses and immunities in response to subpoenas, acting on advice of the Department of Justice is an impeachable offense is absurd, and it is dangerous for our government. Let me explain why. House Democrats' obstruction theory is wrong first and foremost because in a government of laws, asserting privileges and rights to resist compulsion is not obstruction. It's a fundamental right. In Bordenkircher versus Hayes, the Supreme Court explained to punish a person because he has done what the law plainly allows him to do is a due process violation of the most basic sort. And for an agent of the state to pursue a course of action whose objective is to penalize a person's reliance on his legal rights is patently unconstitutional. This is a principle that in the past, in the Clinton impeachment, was recognized across the board, that it would be improper to suggest that asserting rights is an impeachable offense. Harvard Law professor Lawrence Tribe said, quote, "The allegations that invoking privileges and otherwise in using the judicial system to shield information is an abuse of power that should lead to impeachment and removal from office is not only frivolous, but also dangerous." And Manager Nadler then said that the use of a legal privilege is not illegal or impeachable by itself, a legal privilege, executive privilege. And Minority Leader Schumer in the Clinton impeachment expressed the same view.
To suggest that any subject of an investigation, much less the president, with obligations to the institution of the presidency, is abusing power and interfering with an investigation by making legitimate legal claims using due process and asserting constitutional rights is beyond serious consideration.
And that was exactly correct then, and it's exactly correct now. Now, more important than simply the principle that asserting rights can't be considered obstruction, when the rights the president is asserting are based on executive privilege, when they are constitutionally grounded principles that are essential for the separation of powers and for protecting the institution of the office of the presidency, to call that obstruction is to turn the Constitution on its head. Defending the separation of powers cannot be deemed an impeachable offense without destroying the Constitution. Accepting that approach would do permanent damage to the separation of powers, and it would allow the House of Representatives to turn any disagreement with the executive over informational demands into a supposed basis for removing the president from office. It would effectively create for us the very parliamentary system that the framers sought to avoid. Because by making any demand for information and goading the executive to a refusal and treating that then as impeachable, the House would effectively be able to function with a no-confidence vote power. Now, that is not the framers' design. The legislative and executive branches frequently clash on questions of constitutional interpretation, including about congressional demands for information. These conflicts have happened since the founding. In 1796, George Washington, first president, resisted demands from Congress for information about the negotiation of the Jay Treaty. And there have been conflicts between the executive and the Congress in virtually every administration since then about congressional demands for information. The Founding Fathers expected the branches to have these conflicts. James Madison pointed out that the legislative, executive, and judicial departments must, in the exercise of their functions, be guided by the text of the Constitution according to its own interpretation of it, each according to its own interpretation of it. It was recognized that there would be friction. Similarly, in Federalist 51, Madison pointed out that the great security against a gradual concentration of the several powers in the same department consists in giving to those who administer each department the necessary constitutional means and personal motives to resist encroachment of the others. This is checks and balances, this friction, this clashing between the branches. It is not evidence of an impeachable offense. It's the separation of powers in its practical operation. It's part of the constitutional design. Now, the proper and historically accepted way that these disagreements have been resolved is through the constitutionally mandated accommodations process. Courts have explained that the branches are required to engage in an accommodations process to resolve disagreements where there's a clash over a demand for information. As the D.C. Circuit has explained, when Congress asks for information from the executive branch, that triggers, quote, an implicit constitutional mandate to seek optimal accommodation of the needs of the conflicting branches, end quote. The goal is to accommodate the needs of both branches to reach a compromise. If that accommodation process fails, Congress has other tools at its disposal to address a disagreement. The House traditionally has proceeded to contempt, to a vote on a contempt resolution. In recent times, the House has taken the position that it may sue in the courts to determine the validity of its subpoenas and secure an injunction to enforce them. Now, the House managers have pointed out that the Trump administration, when it was sued in the McGahn case and other cases, has taken the view that those cases are not justiciable in Article III courts. That is correct. That is the view of the Trump administration. That was the view of the Obama administration. And so there is that resistance in the court cases to the jurisdiction of the courts to address those. But I think House managers are missing the point when they identify that position that the administration has taken. Because the House cannot claim that they have a mechanism for going to court. They're in court right now asserting that mechanism in the McGahn case. And then simultaneously claim that, well, they don't have to bother with that mechanism, they can jump straight to impeachment. Impeachment under the Constitution is the thermonuclear weapon of interbranch friction. And where there is something like a rifle or a bazooka at the House's disposal to address some friction with the executive branch, that is the next step. It is incrementalism in the Constitution, not jumping straight to impeachment, that is the solution. If the House could jump straight to impeachment, that would alter the relationship between the branches. It would suggest that the House could make itself superior over the executive, dangle the threat of impeachment over any demand for information made to the executive. That's contrary to the framers' plan. Madison explained that where the executive and the legislative branches come into conflict, this is in Federalist 49, he said, quote, neither of them, it is evident, can pretend to an exclusive or superior right of settling the boundaries between their respective powers, end quote. But that is exactly what the House managers have asserted in this case. They have said that the House becomes supreme, there's no need for them to go to court, the executive must be wrong, any resistance to their subpoena is obstruction. If you claim that our subpoena is invalid, we don't have to do anything to address that concern. We will just impeach you because resistance is obstruction of Congress. And the House committee even put it this way in their report, the Judiciary Committee. They said that the House itself, they effectively have said that the House is the judge of its own powers because what they said was, quote, the Constitution gives the House the final word, end quote. That's on page 154 of the House Judiciary Committee report. And what that is essentially saying, they point to the fact that Article 1, Section 2 gives the House the sole power of impeachment. And they claim that because it's the sole power of impeachment, the courts have no role, the House is the final word, it's the judge of its own powers. But that's contrary to the constitutional design. There's no power that is unchecked in the Constitution. The sole power of impeachment given to the House simply means that that power is given solely to the House, not anywhere else. The Constitution does not say that the power of impeachment is the paramount power that makes all other constitutional rights and privileges and prerogatives of the other branches fall away. The framers recognized that there could be partisan impeachments. There could be impeachments for the wrong reasons. And they did not strip the executive branch of any of its means for protecting its own sphere of authority, its own prerogatives under the Constitution. Those principles of executive privilege, those immunities still survive, even in the context of impeachment. The power of impeachment is not like the House can simply flip a switch and say, now we're in impeachment, and they have constitutional kryptonite that makes the powers of the executive eliminated. So when there are these conflicts, even in the context of an impeachment inquiry, the executive can continue to assert its privileges and prerogatives under the Constitution, and indeed it must, in order to protect the institutional interests of the office of the presidency and to preserve the proper balance between the branches under the Constitution. Professor Turley rightly pointed out that by claiming Congress can demand any testimony or documents and then impeach any president who dares to go to the courts, House Democrats were advancing a position that was, quote, entirely untenable and abusive of an impeachment, end quote. Other scholars agree. In the Clinton impeachment, Professor Susan Lowe Block testified that, quote, impeaching a president for invoking lawful privileges is a dangerous and ominous precedent, end quote. It would achieve exactly the result that Gouverneur Morris, one of the framers, warned against at the Constitutional Convention. He explained that, quote, when we make him, referring to the president, amenable to justice, however, we should take care to provide some mode that will not make him dependent on the legislature, end quote. That is exactly what this article of impeachment would do. It would make the president dependent on the legislature, because any demand for information made by Congress could be used as a threat of impeachment to enforce compliance by the executive. And the very theory that the House Democrats have asserted is that there can be no assertions of privileges, no constitutionally based prerogatives of the executive to stand in the way. If that theory were true, virtually every president could have been impeached. Virtually every president has asserted at one time or another these constitutional prerogatives. President Obama famously, in the Fast and Furious investigation, refused to turn over documents that led to his attorney general being held in contempt. But that didn't lead to impeachment. And there could be a long list. Professor Turley testified there'd be a very long list of presidents who would have to be distinguished if the principles being asserted now, in this case, were applied to all past presidents in history. Now, the House Democrats have given a few different justifications for this approach, but I would submit none can be reconciled with the Constitution. They say that if we cannot impeach the president for this obstruction, then the president is above the law. Not so. As I think I've pointed out, the president is staying within the law, asserting the law, relying on the legal advice from the Department of Justice to make his arguments based on long-recognized constitutional principles, and indeed is making the fundamental point with respect to the subpoenas that it is Congress that is not above the law. It's the House. the House has to follow the law as well, has to issue valid subpoenas. And if the law isn't followed, those subpoenas are null and void, and the executive doesn't have to comply with them. The House Democrats say that they shouldn't go to the courts because the courts have no role in impeachment. I think I've pointed out that the House Democrats can't say that they have just because of the provision of the sole power of impeachment, that it's the paramount power and that no other branch plays any role in providing a check on how that power is exercised. And in addition, the House Democrats have gone to court. In the McGahn case that they're litigating right now, they have asserted that that is part of the impeachment inquiry. The Trump administration has explained that it was not validly part of the impeachment inquiry, but that is the ground on which they are litigating that. They say that they have no time for the courts. I think what that really means is they have no time for the rule of law in the way that they're pursuing the inquiry. The other day, one of the House managers actually said on the floor of the Senate that they had to get moving. They couldn't wait for litigation because they had to impeach the president before the election. That's not a valid reason to not pursue litigation in the courts. And I think it's relevant to bear in mind, what sort of delay are we talking about? In the McGahn case that the House managers referred to a number of times, which they had pointed out they presented as being very long and drawn out, they issued a subpoena in April, but they did not file a lawsuit until August. By November 25th, they had a decision from the district court, and it was argued on appeal in the D.C. Circuit on January 3rd. For litigation, that's pretty fast, and it can go faster. In the Nixon case, during Watergate, the special prosecutor issued a subpoena on April 18th, 1974. On May 20th, so in less than a month, the district court denied a motion to quash the subpoena. On May 31st, the Supreme Court agreed to hear the case, granting cert before judgment in the Court of Appeals, and on July 24th, the Supreme Court issued a decision. That's lightning fast. So when there is urgency to the case, when there's a reason for it, there can be expedition in the courts, and a decision can be had in a timely manner. In the one case that actually arose from these impeachment proceedings, it was the House that derailed the case. This was the case involving Deputy National Security Advisor Charlie Kupperman, because when he received a subpoena, he went to court and asked the court for a declaratory judgment explaining what his obligations were. Should he take the directive from the president that he was immune and not go, or should he obey the subpoena? Now, in that case, he filed suit on October 25th. The court, within a few days, set an expedited briefing schedule, but the House withdrew the subpoena on November 5th, just 11 days later, in order to moot the case. So I think litigation is a viable avenue, along with the accommodation process as a first step. Then if the House believes that it can go to court and wants to litigate the jurisdiction and litigate the validity of its subpoenas, that's also available to them. But impeachment, as the first step, doesn't make any sense. And I should point out, in part, when the House managers say they didn't have time to litigate, they didn't have time to go to the courts, but they now come to this chamber and say, this chamber should issue some more subpoenas, this chamber should get some witnesses that we didn't bother to fight about. What do you think will happen then? That there won't be similar assertions of privilege and immunity, that there wouldn't be litigation about that? Again, this goes back to the point that I made. If you put your imprimatur on a process that was broken and say, yes, that was a great way to run things, this was a great package to bring here, and we'll clean up the mess and issue subpoenas and try to do all the work that wasn't done, then that becomes the new normal. And that doesn't make sense for this body. The proper way to have things handled is to have the House, if it wants to bring an impeachment here ready for trial, it has to do the investigation. The information it wants to get, if there's going to be resistance, that has to be resolved, and it has to be ready to proceed, not transfer the responsibility to this chamber to do the work that hasn't been done. They also assert that President Trump's assertion of these privileges is somehow different because it's unprecedented and it's categorical. Well, it's unprecedented perhaps in the sense that there was a broad statement that a lot of subpoenas wouldn't be complied with, but that's because it was unprecedented for the House to begin these proceedings without voting to authorize a committee to issue the subpoenas. That was the first unprecedented step. That's what had never happened before in history. So of course the response to that would be in some sense unprecedented. And the President simply pointed out that without that vote, there were no valid subpoenas. And there have also been categorical refusals in the past. President Truman, when the House Committee on Un-American Activities in 1948 issued subpoenas to his administration, issued a directive to the entire executive branch that any subpoena or demand or request for information, reports, or files of the nature described in those subpoenas shall be respectfully declined on the basis of this directive, and he referred all such inquiries to the office of the President for such response as the President may determine to be in the public interest. And the Truman administration responded to none of them. A last point on the House Democrats' claim that the privileges simply disappear because this is the impeachment power of the House. They have referred a number of times to United States versus Nixon, the Supreme Court decision, suggesting that that somehow determines that when you're in an impeachment inquiry, executive privilege falls away. Well, that's not true. In fact, United States versus Nixon was not even actually addressing a congressional subpoena. It was a subpoena from the special prosecutor. And even in that context, the court did not say that executive privilege simply disappears. Instead, this court said, quote, "It is necessary to resolve these competing interests." They're the interest of the judicial branch in administering a criminal prosecution, a case where the evidence was needed. These competing interests in a manner that preserves the essential functions of each branch. And it even held out the possibility that in the field of foreign relations and national security, there might be something approaching an absolute executive privilege. And that's exactly the field that we're in this case, foreign relations and national security matters. Another thing that you've heard is that President Clinton voluntarily cooperated with the investigation that led to his impeachment, produced tens of thousands of documents. But that's not really accurate. That was only after long litigation again and again about assertions of privilege. He asserted numerous privileges. The House Judiciary Committee then explained, quote, "During the Lewinsky investigation, President Clinton abused his power through repeated frivolous assertions of executive privilege by at least 5 of his aides," end quote. Unlike the House in this case, independent counsel Starr first negotiated with the White House and then litigated those claims and got them resolved. Ultimately, the House managers argue that all of the problems with their obstruction theory should be brushed aside, and the President's assertions of immunities and defenses have to be treated as something nefarious, because as Mr. Nadler put it, only guilty people try to hide the evidence. That's what he said last Tuesday night. And Mr. Schiff similarly said in discussing the assertion of the executive branch's constitutional rights that, quote, "The innocent do not act this way," end quote. Really? Is that the principle in the United States of America? That if you assert legal privileges or rights, that means you're guilty? That the innocent don't assert their rights? That the President can't defend the constitutional prerogatives of his office? That doesn't make any sense. At bottom, the second article of impeachment comes down to a dispute over a legal issue relating to constitutional limits on the ability of the House to compel information from the executive. No matter how House Democrats try to dress up their charges, a difference of legal opinion does not rise to the level of impeachment. Until now, the House has repeatedly rejected attempts to impeach presidents based on legal disputes over assertions of privilege. As Judge Starr pointed out, in the Clinton proceeding, the House Judiciary Committee concluded that the president had improperly exercised executive privilege, yet still concluded that it did not have the ability to second-guess the rationale behind the president or what was in his mind asserting executive privilege, and that it could not treat that as an impeachable offense. It rejected an article of impeachment based on Clinton's assertions of privilege. And as the House Democrats' own witness, Professor Gerhardt, has explained, in 1843, President Tyler similarly was investigated for potential impeachment. His attempts to protect and assert what he regarded as the prerogatives of his office, because he had resisted demands for information from Congress. Professor Gerhardt explained that Tyler's attempts to protect and assert what he regarded as the prerogatives of his office were a function of his constitutional and policy judgments, and they could not be used, the Congress determined, to impeach him. President Trump's resistance to congressional subpoenas was no less a function of his constitutional and policy judgments, and it provides no basis to impeach him. I'd like to close with a final thought. One of the greatest issues, and perhaps the greatest issue for your consideration in this case, is how the precedent set in this case will affect the future. The framers recognized that there would be partisan and illegitimate impeachments. Hamilton expressly warned in Federalist Number 65 about impeachments that reflected what he called, quote, the persecution of an intemperate or designing majority in the House of Representatives, end quote. That is exactly what this case presents. And Justice Story recognized that the Senate provided the proper tribunal for trying impeachments because it was believed by the framers to have a greater sense of obligation to the future, to future generations, not to be swayed by the passions of the moment. And one of the essential questions here is, will this chamber adopt a standard for impeachment, a diluted standard, that fundamentally disrupts, damages, alters the separation of powers in our constitutional structure of government? Because that is what both the first article, for reasons that Judge Starr and Professor Dershowitz have covered, and the second article, the obstruction charge, would do. And so I'll close just with a quotation from one of the Republican senators who crossed the aisle and voted against convicting President Andrew Johnson during his impeachment trial. It was Lyman Trumbull, who explained, I think, the great principle that applies here. He said, quote, once we set the example of impeaching a president for what, when the excitement of the hour shall have subsided, will be regarded as insufficient causes, no future president will be safe. And what then becomes of the checks and balances of the Constitution, so carefully devised and so vital to its perpetuity? They are all gone. Thank you, Mr. Chief Justice. I'll yield to Mr. Sekulow.
Mr. Chief Justice, members of the Senate, House managers. Mr. Philbin talked about the importance, just concluded on the importance of executive privilege. Professor Turley, who testified before the House, said we have 3 branches of government, not 2. If you impeach a president, if you make a high crime and misdemeanor out of going to court, it is an abuse of power. It's your abuse of power. With regard to executive privilege, it was Mr. Nadler who called it executive privilege and other nonsense. When Attorney General Holder refused to comply with subpoenas, President Obama invoked executive privilege, arguing, and I quote, compelled disclosure would be inconsistent with the separation of powers established in the Constitution. Executive power and other nonsense. Manager Schiff wrote that the White House assertion of executive privilege was backed by decades of precedent that has been recognized and has recognized the need for the president and his senior advisors to receive candid advice and information from their top aides, executive privilege, and other nonsense. The nonsense, we talked about this the other night, is to treat the separation of powers and constitutional privileges as if they're asbestos in the ceiling tiles. You can't touch them. That's not the way the Constitution is designed. We're going to now turn our attention to a separate topic. It's one that was been discussed a lot on the floor here and will be discussed now. Presenting for the President is the former Attorney General for the state of Florida, Pam Bondi. She is also a prosecutor, a career prosecutor. She's handled countless cases. She's going to discuss an issue that the House managers have put pretty much at the center of their case, and that's the issue of corruption in Ukraine, particularly with regard to a company known as Burisma. I yield my time, Mr. Chief Justice, to former Attorney General Pam Bondi.
Chief Justice. Senators. Members of the Senate. When the House managers gave you their presentation, when they submitted their brief, they repeatedly referenced Hunter Biden and Burisma. They spoke to you for over 21 hours, and they referenced Biden or Burisma over 400 times. And when they gave these presentations, they said there was nothing to see, it was a sham. This is fiction. In their trial memorandum, the House managers described this as baseless. Now, why did they say that? Why did they invoke Biden or Burisma over 400 times? The reason they needed to do that is because they are here saying that the President must be impeached and removed from office for raising a concern. And that's why we have to talk about this today. They say sham, they say baseless, because they say this because if it's okay for someone to say, hey, you know what, maybe there's something here worth raising, then their case crumbles. Because they have to prove beyond a reasonable doubt that there is no basis to raise this concern. But that's not what public records show. Here are just a few of the public sources that flagged questions surrounding this very same issue. The United Kingdom Serious Fraud Office, Deputy Assistant Secretary of State George Kent, Hunter Biden's former business associate, an ABC White House reporter, Good Morning America, ABC, The Washington Post, The New York Times, Ukrainian law enforcement, and the Obama State Department itself. They all raised this issue. We would prefer not to be talking about this. We would prefer not to be discussing this. But the House managers have placed this squarely at issue, so we must address it. Let's look at the facts. In early 2014, Joe Biden, our Vice President of the United States, led the United States foreign policy in Ukraine with the goal of rooting out corruption. According to an annual study published by Transparency International, during this time, Ukraine was one of the most corrupt countries in the entire world. In Ukraine, there's a natural gas company called Burisma. Burisma has been owned by an oligarch named Mykola Solchevsky. Here's what happened very shortly after Vice President Biden was made U.S. point man for Ukraine. His son, Hunter Biden, ends up on the board of Burisma, working for and paid by the oligarch Zlochevsky. In February 2014, in the wake of anti-corruption uprising by the people of Ukraine, Zlochevsky flees the country, flees Ukraine. Zlochevsky, the oligarch, is well known. George Kent, the very first witness that the Democrats called during their public hearings, testified Zlochevsky stood out for his self-dealings even among other oligarchs. House managers didn't tell you that. Ambassador Kurt Volkler explained that Burisma had a, quote, very bad reputation as a company for corruption and money laundering, end quote. House managers didn't tell you that. Burisma was so corrupt that George Kent said he intervened to prevent U.S. aid from co-sponsoring an event with Burisma. You know what this event was? It was a child's contest, and the prize was a camera. They were so bad, Burisma, that our country wouldn't even co-sponsor a children's event with Burisma. In March 2014, the United Kingdom Serious Fraud Office opens a money laundering investigation into the oligarch Zlochevsky and his company Burisma. The very next month, April 2014, according to a public report, Hunter Biden quietly joins the board of Burisma. Remember, early 2014 was when Vice President Biden began leading Ukraine policy. Here's how Hunter Biden came to join Burisma's board in April 2014. He was brought on the board by Devon Archer, his business partner. Devon Archer was college roommates with Chris Hines, stepson of Secretary of State John Kerry. All three men, Hunter Biden, Devon Archer, and Chris Hines, had all started an investment firm together. Public records show that April 16, 2014, Devon Archer meets with Vice President Biden at the White House. Just 2 days later, on April 18, 2014, is when Hunter Biden quietly joins Burisma, according to public reporting. Remember, this is just 1 month after the United Kingdom Serious Fraud Office opened a money laundering case into Burisma. Hunter Biden joins their board. And not only 10 days after Hunter Biden joins the board, British authorities seize $23 million in British bank accounts connected to the oligarch Zlochevsky, the owner of Burisma. Did Hunter Biden leave the board then? No. The British authorities also announced that it had started a criminal investigation into potential money laundering. Did Hunter Biden leave the board? No. What happened was then, only then, did the company choose to announce that Hunter Biden had joined the board after the assets of Burisma and his oligarch owner, Zlochevsky, were frozen and a criminal investigation had begun. Hunter Biden's decision to join Burisma raised flags almost immediately. One article from May 2014 stated, "The appointment of Joe Biden's son to the board of Ukrainian gas firm Burisma has raised eyebrows the world over." Even an outlet with bias for Democrats pointed out Hunter Biden's activities created a conflict of interest for Joe Biden. The article stated, "The move raises questions about a potential conflict of interest for Joe Biden." Now, even Chris Hines, Hunter Biden's own business partner, had grave concerns. He thought that working with Burisma was unacceptable. This is Chris Hines. He was worried about the corruption, the geopolitical risk, and how bad it would look. So he wisely distances himself from Hunter Biden and Devon Archer's appointments to Burisma. He didn't simply call his stepfather, Secretary of State, and say, I have a problem with this. He didn't tell his friends, hey guys, I'm not getting on the board, I want nothing to do with this. He went so far as to send an email to senior State Department officials about this issue. This is Chris Hines. He wrote, apparently, Devon and Hunter have joined the board of Burisma, and a press release went out today. I can't speak to why they decided to, but there is no investment by our firm in their company. What did Hunter Biden do? He stayed on the board. What did Chris Hines do? He subsequently stopped doing business with his college roommate, Devon Archer, and his friend, Hunter Biden. Chris Hines' spokesperson said, the lack of judgment in this matter was a major catalyst for Mr. Hines ending his business relationship with Mr. Archer and Mr. Biden. Now, the media also noticed. The same day, an ABC News reporter asked Obama White House Press Secretary Jay Carney about it. Here's what happened.
Hunter Biden has now taken a position with the largest oil and gas company, holding company in Ukraine. Is there any concern about at least the appearance of a conflict there? See the Vice President.
I would refer you to the Vice President's office. I saw those reports. Hunter Biden and other members of the Biden family are obviously private citizens, and where they work is not does not reflect an endorsement by the administration or by the Vice President or President, but I would refer you to the Vice President's office.
The next day, the Washington Post ran a story about it. It said, the appointment of the Vice President's son to a Ukrainian oil board looks nepotistic at best, nefarious at worst. Again, the appointment of the Vice President's son to a Ukrainian oil board looks nepotistic at best, nefarious at worst. And the media didn't stop asking questions here. It kept going. Here's ABC.
You have to fight the cancer of corruption.
But then, something strange happened. Just 3 weeks later, a Ukrainian natural gas company, Burisma, accused of corruption, appoints Hunter Biden, seen here in their promotional videos, to their board of directors, paying his firm more than $1 million a year.
Here's more from ABC. Continued on.
And Ukraine wasn't the only country where Hunter Biden's business and his father's diplomacy as vice president intersected. It also happened in China.
This video shows Chinese diplomats greeting Vice President Biden as he arrived in Beijing in December of 2013. Right by his side, his son Hunter. Less than 2 weeks later, Hunter's firm had new business, creating an investment fund in China involving the government-controlled Bank of China. With reports, they hope to raise $1.5 billion.
In fact, every witness who was asked about Hunter Biden's involvement with Burisma agreed there was a potential appearance of a conflict of interest. Multiple House Democrat witnesses, including those from the Department of State, the National Security Council, and others, unanimously testified there was a potential appearance of a conflict of interest. These were their witnesses. How much money did Hunter Biden get for being on the board? Well, you start looking at these bank records. According to reports, between April 2014 and October 2015, Burisma paid more than $3.1 million to Devon Archer and Hunter Biden. That's over the course of a year and a half. How do we know this? Some of Devon Archer's bank records were disclosed during an unrelated federal criminal case having nothing to do with Hunter Biden. These bank records show 17 months that Burisma wired two payments of $83,333, not just for 1 month, for 2 months, for 3 months, but for 17 months. According to Reuters, sources report that of the two payments of $83,333 each, one was for Hunter Biden and one Devon Archer. Now, Hunter Biden was paid significantly more than board members for major U.S. Fortune 100 companies, such as Goldman Sachs, Comcast, Citigroup. The typical board member of these Fortune 100 companies, we know they're titans of their industry, they're highly qualified, and as such, they're well compensated. Even so, Hunter Biden was paid significantly more. This is how well he was compensated. So Hunter Biden is paid over $83,000 a month, while the average American family of four during that time, each year, made less than $54,000. And that's according to U.S. Census Bureau during that time. And this is what's been reported about his work on the board. The Washington Post said, quote, "What specific duties Hunter Biden carried out for Burisma are not fully known," end quote. The New Yorker reported, quote, "Once or twice a year he attended Burisma board meetings and energy forums that took place in Europe," end quote. When speaking with ABC News about his qualifications to be on Burisma's board, Hunter Biden didn't point to any of the usual qualifications of a board member. Hunter Biden had no experience in natural gas, no experience in the energy sector, no experience with Ukrainian regulatory affairs. As far as we know, he doesn't speak Ukrainian. So naturally, the media has asked questions about his board membership. Why was Hunter Biden on this board?
If your last name wasn't Biden, do you think you would have been asked to be on the board of Burisma?
I don't know. Probably not.
So let's go back and talk about his time on the board. Remember, he joined Burisma's board April 2014, while the United Kingdom had an open money laundering case against Burisma and its owner, the oligarch Zlochevsky. On August 20th, 2014, 4 months later, the Ukrainian Prosecutor General's office initiates a money laundering investigation into the same oligarch, Zlochevsky. This is one of 15 investigations into Burisma and Zlochevsky, according to a recent public statement made by the current Prosecutor General. On January 16, 2015, prosecutors put Zlochevsky, the owner of Burisma, on whose Hunter Biden sat on his board, on the country's wanted list for fraud, while Hunter Biden's on the board. Then a British court orders Zlochevsky's $23 million in assets be unfrozen. Why was the money unfrozen? Deputy Assistant Secretary Kent testified to it.
Somebody in the General Prosecutor's Office of Ukraine shut the case, issued a letter to his lawyer, and that money went poof.
So essentially paid a bribe to make the case go away.
That is our strong assumption, yes, sir.
He also testified that the Ukrainian Prosecutor General's office's actions led to the unfreezing of the assets. After George Kent's confirmation, that prosecutor was out. Viktor Shokan becomes the Prosecutor General. This is the prosecutor that you'll hear about later, the one that Vice President Biden has publicly said he wanted out of office. In addition to flagging questions about previous prosecutors' actions, George Kent also specifically voiced other concerns, this time to the Vice President's office about Hunter Biden. In February 2015, he raised concerns about Hunter Biden to Vice President Biden's office.
In a briefing call with the national security staff of the Office of the Vice President in February of 2015, I raised my concern that Hunter Biden's status as a board member could create the perception of a conflict of interests.
But House managers didn't tell you that. This is all while Hunter Biden sat on Burisma's board. Did Hunter Biden stop working for Burisma? No. Did Vice President Biden stop leading the Obama administration's foreign policy efforts in Ukraine? No. In the meantime, Vice President Biden is still at the forefront of the U.S.-Ukraine policy. He pledges $1 billion loan guarantee to Ukraine contingent on its progress in rooting out corruption. Around the same time of the $1 billion announcement, other people raised the issue of a conflict. As Obama administration special envoy for energy policy told The New Yorker, it raised Hunter Biden's participation on the board of Burisma. He raised it directly with the vice president himself. This is a special envoy to President Obama. And the media had questions too. December 8, 2015, the New York Times publishes an article that Prosecutor General Shokan was investigating Burisma and its owner, Solinsky. The Times report, here's their quote, the credibility of the Vice President's anti-corruption message may have been undermined by the association of his son, Hunter Biden, end quote, with Burisma and its owner, Solinsky. And it wasn't just one reporter who asked questions about the line between Burisma and the Obama administration. As we learned recently through reporting on Fox News, on January 19, 2016, there was a meeting between Obama administration officials and Ukrainian prosecutors. Ken Vogel, journalist for the New York Times, asked the State Department about this meeting. He wanted more information about the meeting, quote, where U.S. support for prosecutions of Burisma holdings in the United Kingdom and Ukraine were discussed, end quote. But the story never ran. Around the time of the reported story, January 2016, meeting between the Obama administration and Ukrainian officials took place, according to a Ukrainian press report, as translated, says, quote, the U.S. Department of State made it clear to the Ukrainian authorities that it was linking the $1 billion in loan guarantees to the dismissal of Prosecutor General Viktor Shokan, end quote. Now, we all know from the Obama administration and from the words of Vice President Biden himself, he advocated for the Prosecutor General's dismissal. There was ongoing investigation into the oligarch Solinsky, the owner of Burisma, at the time. We know this because on February 2nd, 2016, the Ukrainian Prosecutor General obtained a renewal of a court order to seize the Ukrainian oligarch's assets. A Kiev Post article published on February 4th, 2016, says the oligarch Solinsky is, quote, suspected of committing a criminal offense of illicit enrichment, end quote. Over the next few weeks, the Vice President had multiple calls with Ukraine's President Poroshenko. Days after the last call, on February 24th, 2016, a D.C. consultant reached out to the State Department to request a meeting to discuss Burisma. We know what she said because the email was released under the Freedom of Information Act. The consultant explicitly invoked Hunter Biden's name as a board member. In an email summarizing the call, the State Department official says that the consultant, quote, noted that 2 high-profile citizens are affiliated with the company, including Hunter Biden as a board member, end quote. She added that the consultant would, quote, like to talk with Undersecretary of State Novelli about getting a better understanding of how the U.S. came to the determination that the country is corrupt, end quote. To be clear, this email documents that the U.S. government had determined Burisma to be corrupt. And the consultant was seeking a meeting with an extremely senior State Department official to discuss the U.S. government's position. Her pitch for the meeting specifically used Hunter Biden's name, and according to the email, the meeting was set for a few days later. And later that month, on March 29, 2016, the Ukrainian parliament finally votes to fire the Prosecutor General. This is the Prosecutor General investigating the oligarch, owner of Burisma, on whose board Hunter Biden sat. 2 days after the Prosecutor General is voted out, Vice President Biden announces that the U.S. will provide $335 million in security assistance to Ukraine. He soon announces that the U.S. will provide $1 billion in loan guarantees to Ukraine. Now let's talk about one of the Democrats' central witnesses, Ambassador Jovanovic. In May 2016, Ambassador Jovanovic was nominated to be ambassador in Ukraine. Here's what happened when she was preparing for her Senate confirmation hearing.
Congresswoman Stefanik had asked you how the Obama-Biden State Department had prepared you to answer questions about Burisma and Hunter Biden specifically. You recall that?
Yes.
Out of thousands of companies in the Ukraine, the only one that you recall the Obama-Biden State Department preparing you to answer questions about was the one where the Vice President's son was on the board. Is that fair?
Yes. So she's being prepared to come before all of you, and talk about world issues. Going to be in charge of the Ukraine. And what did they feel the only company, the company that it was important to brief her on in case she got a question? Burisma. Ambassador Jovanovic was confirmed July 2016 as the Obama administration was coming to a close. In September 2016, a Ukrainian court cancels the oligarch Zlochevsky's arrest warrant for lack of progress in the case. In mid-January 2017, Burisma announces that all legal proceedings against it and Zlochevsky have been closed. Both of these things happened while Hunter Biden sat on the board of Burisma. Around this time, Vice President Biden leaves office. Years later now, former Vice President Biden publicly details what we know happened, his threat to withhold more than $1 billion in loan guarantees unless Shokan was fired. Here's the Vice President.
I said, no, I'm not going to, we're not going to give you the $1 billion. They said, you have no authority. You're not the president. The president said. I said, call him. I said, I'm telling you, you're not getting the $1 billion. I said, you're not getting the $1 billion. I'm going to be leaving here. And I think it was, what, 6 hours? I looked, I said, I'm leaving in 6 hours. If the prosecutor's not fired, you're not getting the money. Well, son of a bitch. Got fired. And they put in place someone who was solid at the time.
What he didn't say on that video, according to the New York Times, this was the prosecutor investigating Burisma, Shokan. What he also didn't say on the video was that his son was being paid significant amounts by the oligarch, owner of Burisma, to sit on that board. Only then does Hunter Biden leave the board. He stays on the board until April 2019. Now, in November 2019, Hunter Biden signs an affidavit saying, quote, he's been unemployed and has no other monthly income since May 2019. This was in November of 2019. So we know from after April 2019 to May 2019, through November 2019, he was unemployed by his own statement. April 2019 to November 2019. Despite his resignation from the board, the media has continued to raise the issue relating to a potential conflict of interest. On July 22, 2019, the Washington Post wrote, the fired Prosecutor General Shokan, quote, believes his ouster was because of his interest in the company, end quote, referring to Burisma. The Post further wrote that, quote, had he remained in his post, he would have questioned Hunter Biden. On July 25th, 2019, 3 days later, President Trump speaks with President Solinsky. He says, the other thing, there's a lot of talk about Biden's son, that Biden stopped the prosecution, and a lot of people want to find out about that. So whatever you can do with this Attorney General would be great. Biden went around bragging that he stopped the prosecution. So if you can look into it, looks horrible to me. End quote. The House managers talked about the Bidens of Burisma 400 times, but they never gave you the full picture. But here are those who did. The United Kingdom Serious Fraud Unit, Deputy Assistant Secretary of State George Kent, Chris Hines, the ABC White House reporter, ABC, Good Morning America, The Washington Post, The New York Times, Ukrainian law enforcement, and the Obama State Department itself. They all thought there was cause to raise the issue about the Bidens and Burisma. Now the House managers might say, without evidence, that everything we just have said has been debunked, that the evidence points entirely and unequivocally in the other direction. That is a distraction. You've heard from the House managers. They do not believe that there was any concern to raise here, that all of this was baseless. And all we are saying is that there was a basis to talk about this, to raise this issue, and that is enough. I yield my time.
Thank you, Mr. Chief Justice. Majority Leader McConnell, Democratic Leader Schumer, House managers, members of the Senate, this will be our last presentation before dinner. The next lawyer representing the President is Eric Hirschman. He's a partner in the Kasowitz firm, a law firm which has been representing the President for over 2 decades. He is a former prosecutor and trial lawyer, and he ran a natural gas company in the United States. He is going to discuss additional evidence the House managers ignored or misstated and how other presidents might have measured up under this new impeachment standard.
Mr. Chief Justice, members of the Senate, I am Eric Hirschman. I have the honor and privilege of representing the President of the United States in these proceedings. I have been carefully listening to and reviewing the House manager's case. That case pretty much boils down to one straightforward contention, that the President abused his power to promote his own personal interests and not our country's interests. The House managers say that the President did not take the steps that they allege for the benefit of our country, but only for his own personal benefit. But if that's wrong, if what the President had wanted would have benefited our country, then the managers have not met their burden, and these articles of impeachment must be rejected. As we will see, the House managers do not come close to meeting their burden. Last week, Manager Schiff said that the investigations President Trump supposedly asked President Solinsky about on the July 25th call could not have been in the country's interest because he said they were, quote unquote, discredited entirely. The House managers say that the investigations had been debunked. They were sham investigations. So now we have the question, were they really? The House managers, in the over 21 hours of the repetitive presentation, never found the time to support those conclusory statements. Was it in fact true that any investigation had been debunked? The House managers do not identify for you who supposedly conducted any investigations, who supposedly did the debunking, who discredited it, where and when were any such investigations conducted, when were the results published, and much more is left unanswered. Attorney General Bondi went through for you some of what we know about Burisma and its millions of dollars in payments to Vice President Biden's son and his son's business partner. There is no question that any rational person would like to understand what happened. I'm going to go through some additional evidence which was easily available to the House managers, but which they never sought or considered. Based on what Attorney General Bondi told you and this additional evidence, you can judge for yourself whether the conduct was suspect. As you know, one of the issues concerned Hunter Biden's involvement with the Ukrainian natural gas company, which paid him millions of dollars while his father was vice president and was in charge of the Ukrainian portfolio during the prior administration. I'll get to those supposedly discredited allegations identified by the House managers in a few minutes. The other issue was what Manager Schiff called, quote, the baseless conspiracy theory that Ukraine, not Russia, interfered in the 2016 election, close quote. Manager Schiff said that President Trump wanted to, quote, erase from history his previous political misconduct, close quote. But there was no previous political misconduct. If any theory has actually been discredited, it's the theory that President Trump colluded with Russia in 2016. It was that theory that was discredited, and discredited entirely by Mr. Mueller's massive investigation, the same investigation the Democrats demanded since President Trump took office, the same investigation they knew, they were absolutely sure would expose such collusion. The same investigation which, after 22 months of exhaustive work, at a cost to the taxpayers of $32 million, found no conspiracy and no evidence of Russian collusion with the Trump campaign. And as we will see, the Democrats are as wrong now about the articles of impeachment as they were in 2016 about the Russian collusion. As to the other incident President Trump mentioned, the one concerning the Ukrainian gas company Burisma, well, I actually think this is something that is undisputed, that Ukraine had a particularly bad corruption problem. It was so corrupt that dealing with corruption and solving the corruption was a priority for our U.S. foreign policy. Here is how one knowledgeable observer of Ukraine put it in 2015, quote, it's not enough to set up a new anti-corruption bureau and establish a special prosecutor fighting corruption. The office of the general prosecutor desperately needs reform. The judiciary should be overhauled. The energy sector needs to be competitive, ruled by market principles, not sweetheart deals. It's not enough to push through laws to increase transparency with regard to official sources of income. Senior elected officials have to remove all conflicts between their business interests and their government responsibilities. Now, as Attorney General Bondi said, here are the facts we do know about Hunter Biden's involvement with Ukraine. Burisma, a Ukrainian natural gas company, paid Hunter Biden millions of dollars to serve on its board of directors. He did not have any relevant expertise or experience. He had no expertise or experience in the natural gas industry. He had no known expertise in corporate governance, nor any expertise in Ukrainian law. He doesn't, so far as we know, speak Ukrainian. So why? Why did Burisma want Hunter Biden on its board? Why did they want to pay him millions of dollars? Well, he did have one qualification. He was the son of the Vice President of the United States. He was the son of the man in charge of the Ukrainian portfolio for the prior administration. And we are to believe there is nothing to see here. That for anyone to investigate or inquire about this would be a sham. Nothing to see here. But tellingly, Hunter Biden's attorney, on October 13, 2019, issued a statement on his behalf. He indicated that in April 2014, Hunter was asked to join the board of Burisma. Then states Hunter stepped off Burisma's board in April 2019. Now listen to the commitment that Hunter Biden is supposedly willing to make to all of us. Hunter makes the following commitment. Under a Biden administration, Hunter will readily comply with any and all guidelines or standards a President Biden may issue to address purported conflicts of interest or the appearance of such conflicts, including any restrictions related to overseas business interests. That statement almost tells us all we need to know. That's the rule that should have been in place in 2014, because there already was an Obama-Biden administration. What changed? What changed? Remember a couple of minutes ago when I quoted an expert on Ukraine, the one who said that Ukraine must clean up its energy sector, the one who said that Ukraine's senior elected officials have to remove all conflicts between their business interests and their government responsibilities. You know who said that about Ukraine? Vice President Joe Biden in December of 2015. Vice President Biden went to Ukraine approximately 12 to 13 times. He spoke with legislators, business people, officials. He was purportedly fighting corruption in Ukraine. He was urging Ukraine to investigate and uproot corruption. One thing he apparently did not do, however, was to tell his son not to trade on his family connections. He did not tell his son to especially stay away from the energy sector in the very corruption-ridden country Vice President Biden was responsible for. And Manager Schiff says, move along. There's nothing to see here. What are the House managers afraid of finding out? In an interview with ABC in October of last year, Hunter Biden said he was on the board of Burisma to focus on principles of corporate governance and transparency.
Bottom line is that I know that I was completely qualified to be on the board to head up the Corporate Governance and Transparency Committee on the board. And that's all that I focused on.
But when asked how much money Burisma was paying him, he responded he doesn't want to open his kimono and disclose how much. He does refer to public reports about how much he was being paid, but as we now know, he was being paid far more than what was in the public record.
You were paid $50,000 a month for your position?
Look, I'm a private citizen. One thing that I don't have to do is sit here and open my kimono as it relates to how much money I make or did or didn't. But it's all been reported.
So what was the real reason that Hunter Biden, the vice president's son, was being paid by Burisma? Was it based on his knowledge and understanding of the natural gas industry in Ukraine? Was he going to discuss how our government regulates the energy industry here? Was he going to discuss how we set gas rates? Was he going to discuss pipeline development, construction, or environmental impact statements? Did he know anything about the natural gas industry at all? Of course not. So what was the reason? I think we do not need to look any further than the explanation that Hunter Biden gave during the ABC interview when he was asked why. Here's what he had to say.
If your last name wasn't Biden, do you think you would have been asked to be on the board of Burisma?
I don't know. I don't know. Probably not. I don't think that there's a lot of things that would have happened in my life that if my last name wasn't Biden.
And as if to confirm how suspect this conduct was, that it should be a concern to our country, Hunter Biden and his lawyer could not even keep their story straight. Compare the press release that was issued by Burisma on May 12, 2014, with Hunter Biden's lawyer statement on October 13th of 2019. The May 2014 press release begins, R for Robert Hunter Biden will be in charge of Holdings Legal Unit. He was going to be in charge of a Ukrainian gas company owned by an oligarch's legal unit. However, in his lawyer's statement in October of 2019, after his involvement with Burisma came under renewed public scrutiny, he now claims at no time was Hunter in charge of the company's legal affairs. Which is it? What was Hunter Biden doing at Burisma in exchange for millions of dollars? Who knows? What were they looking to hide? So much for his corporate governance and transparency. But let's take a step back and realize what actually transpired. Because the House managers would have us believe this had nothing at all to do with our government, nothing at all to do with our country's interests, nothing at all to do with our vice president, nothing at all to do with the State Department. It simply was private citizen Hunter Biden doing his own private business. It was purely coincidental that it was in his father's portfolio in Ukraine, in the exact sector, the energy sector, that his father said was corrupt. But we have a document here again, something that House managers did not show you or even put before the House before voting these baseless articles of impeachment. If you look at this email, it's an email from Chris Hines, and as Attorney Bondi already told you, he is the stepson of the then Secretary of State John Kerry, and who was the other business partner with Hunter Biden and Devin Archer. Our Secretary of State's stepson and our Vice President's son are in business together. It was sent on May 13, 2014 to the official government email addresses of two senior people at the State Department. And who are these two people? The Chief of Staff to the Secretary of State and the Special Advisor to the Secretary of State. The subject line in the email is not corporate transparency. It's not corporate governance. It's not, here's a heads up. The subject line is Ukraine. Chris Hines certainly understood the sensitivity to our U.S. foreign policy. And what does the Secretary of State's stepson say about Hunter Biden and Devin Archer? He says this. Apparently, Devin and Hunter both joined the board of Burisma, and a press release went out today. I can't speak to why they decided to, but there was no investment by our firm in the company. What is the most telling thing about this? It is clear that the Chief of Staff and the Special Assistant to the Secretary already knew who Devin was because Mr. Hines did not include his last name. It's just Devin. And they obviously knew who Hunter was because, again, it's Hunter Biden. This is Chris Hines saying, I can't speak to why they decided to join the board of Burisma. He's their business partner. Not that there are good corporate reasons and they're going there for corporate government. Not that they're there to enhance corporate transparency. Not that they are there to further U.S. policy. Not that they are there to help fight corruption in Ukraine. Not that they are there to ensure that boards of directors' compensation and benefits are publicly disclosed. Nothing like that. He cannot say those things because he knows Devin and Hunter well. And he knows they have no particular qualifications whatsoever to do those things, especially for a Ukrainian gas company. Instead, Mr. Hines is plainly going on the record to report what Hunter and Devin were doing through official channels and to take pains to disassociate himself from what they were doing. And what did the State Department do with this information that the Secretary of State's stepson thought they needed to know? Apparently, nothing. They did not tell Mr. Hines to stay away. They did not tell Mr. Hines there's no problem. Nothing. But all this, the House managers want us to believe, does not even merit any inquiry. Anyone asking for one, anyone discussing one, is now corrupt. Does it merit an inquiry why a corrupt company in a corrupt country would be paying our Vice President's son $1 million per year, plus it appears some additional expenses, and paying his business partner an additional $1 million per year? Secretary of State Kerry's stepson thought it was important enough to report. Why aren't the House managers concerned? And I ask you, why would it not merit an investigation? And you know something else about Vice President Biden? Well, back in January of 2018, as you heard, former Vice President Biden bragged that he had pressured the Ukrainians, threatened them, indeed coerced them, into firing the state prosecutor who reportedly was investigating the very company that paid millions of dollars to his son. He bragged that he gave them 6 hours to fire the prosecutor, or he would cut off $1 billion in U.S. loan guarantees.
I said, no, I'm not going to, or we're not going to give you the $1 billion. They said, you have no authority. You're not the president. The president said. I said, call him. I said, I'm telling you, you're not getting the $1 billion. I said, you're not getting the $1 billion. I'm going to be leaving here. And I think it was, what, 6 hours? I looked, I said, I'm leaving in 6 hours. If the prosecutor's not fired, you're not getting the money. Well, son of a bitch. Got fired. And they put in place someone who was solid at the time.
Are we really to believe that it was the policy of our government to withhold $1 billion? $1 billion of needed guarantees in aid to Ukraine unless they fired a prosecutor on the spot? Was that really our policy? We have all heard continuously from the managers, and many agree about the risks to the Ukrainians posed by the Russians. We have heard the managers say that a slight delay in providing funding to Ukraine endangers our national security and jeopardizes our interests, and therefore the president must immediately be removed from office. Yet they also argue that it was the official policy of our country to withhold $1 billion unless one individual was fired within a certain matter of hours. Was that really, or could it ever be, our United States policy? According to the House manager's theory, we were willing to jeopardize Ukrainians unless somebody who happened to be investigating Burisma was promptly fired. Were we going to jeopardize the Ukrainian economy because a prosecutor was not fired in the 6-hour time period Vice President Biden demanded? Does anyone really believe that was or ever could be our United States foreign policy? And just in case the managers or others try to argue, no, he wasn't serious about that, he was just bluffing, what kind of message would that send to the Russians about our support for the Ukrainians, that we would bluff and bluff with the Ukrainian economy? From 2014 to 2017, Vice President Biden claimed to be on a crusade against corruption in Ukraine. He repeatedly spoke about how the cancer of corruption was endemic in Ukraine and hobbled Ukraine, how Ukraine faced no more consequential mission than confronting corruption. And he encouraged Ukraine to close the space for corrupt middlemen who rip off the Ukrainian people. The Vice President railed against monopolistic behavior where a select few profit from so many sweetheart deals that has characterized that country for so long. And on his last official visit to Ukraine, 4 days before he left office, he spoke out against corruption and oligarchy that eats away like a cancer, and against corruption which continues to eat away at Ukraine's democracy within. Why was Vice President Biden doing this? Was he so concerned about corruption in Ukraine, even singling out that country's energy sector? Because corruption in Ukraine is a critical policy concern for our country. But during this whole time, what else was happening? His son and his son's business partner were raking in over $1 million a year for what was regarded as one of the most corrupt Ukrainian companies in the energy sector, owned and controlled by one of the most corrupt oligarchs. Were Vice President Biden's words and advice to Ukraine just hollow? According to the House managers, the answer apparently is yes. They were empty words, at least when it came to anyone questioning his son's own sweetheart deal, his own son's deal with Ukraine's corruption and oligarchy. Again, to raise Manager Schiff's own question, what kind of message did this send to future U.S. government officials? Your family can accept money from foreign corrupt companies? No problem. You can pay family members of our highest government officials, and no one is allowed to even ask questions. What was going on? We have to just accept now the House manager's conclusory statements, like sham, discredited, even though no one has ever investigated. Why? And can you imagine what House Manager Schiff and his fellow Democratic representatives would say if it were President Trump's children on an oligarch's payroll? And when it finally appeared that a true Ukrainian corruption fighter had assumed the country's presidency, President Trump was not supposed to, he was not permitted to, follow up on Vice President Biden's own words about fighting corruption and try to make those words something other than empty. And according to the House managers, Ukrainian corruption is now only a private interest. It no longer is a serious, important concern for our country. Now, I want to take a moment to cover a few additional points about the July 25th telephone call in which the House managers believe that the President in the United States, in their words, was shaking down and pressuring the President of Ukraine to do his personal bidding. First of all, this was not the first telephone call that the President of the United States had with other foreign leaders. So think about this for a moment. The call was routed through the Situation Room. It was a scheduled call. There were other people on the call. There were other people taking notes, and obviously the President was aware of that fact. The House managers talk about the fact that the President did not follow the approved talking points, as if the President, any President, is obligated to follow approved talking points. And the last time I checked, and I think this is clear to the American people, President Trump knows how to speak his mind. But remember the fake transcript that Manager Schiff read when he was before the Intelligence Committee? His mob, gangster-like fake rendition of the call? Well, I prosecuted organized crime for years. The type of description of what goes on, what House Manager Schiff tried to create for the American people, is completely detached from reality. It is as if we were supposed to believe that mobsters would invite people they do not know into an organized crime meeting to sit around and take notes to establish the corrupt intent. Manager Schiff, our jobs as prosecutors, and I know you were one, would have been a lot easier if that were how it worked. Think about what he is saying. Think about the manager's position, that our president decided, with corrupt intent, to shake down, in their words, another foreign leader, and he decided to do it in front of everyone in a documented conversation, in the presence of people he did not even know, just so he can get this personal benefit, and that was not in our country's interest. The logic is flawed. It is completely illogical, because that is not what happened. And that is why Manager Schiff ran away from the actual transcript. That is why he created his own fake conversation. But I would like to just address another point from the transcript of the July 25th phone call. The House managers allege that an Oval Office meeting with the President was critical to the newly elected Ukrainian president because it would signal to Russia, which had invaded Ukraine in 2014 and still occupied Ukrainian territory, that Ukraine could count on American support. They actually argue that it was a quid pro quo, that the President withheld this critical Oval Office meeting that would deter the Russians and save the Ukrainians because he wanted something personal. Now, if that was in fact critical to President Solinsky for the safety of his own citizens, he would have immediately jumped at the opportunity to come to the Oval Office, especially when President Trump offered him that invitation during the July 25th call. But let's see what President Solinsky actually says when he's invited to Washington on that call. He does not say, oh, this is what I would like to do, it's critical for my people, we will arrange it immediately. His response is, I would be very happy to come and would be happy to meet you personally and get to know you better. On the other hand, I believe that on September 1st, we will be in Poland and we can meet in Poland, hopefully. In an Oval Office meeting, if an Oval Office meeting was critical to President Solinsky, that was the time to say so, not to suggest another venue. When we look at the evidence that is before us, it is clear that the only people who talked about having an Oval Office meeting were lower-level government employees who thought it was a good idea. But the principals involved, those who actually make the decisions, President Solinsky and President Trump, to them, it was not critical, it was not material, and it was definitely never a quid pro quo. What was important to President Solinsky was not an Oval Office meeting, but the lethal weapons that President Trump supplied to Ukraine and the sanctions that President Trump enforced against the Russians. That is what the transcript of the July 25th call demonstrates. Let us now consider what President Solinsky knew about the support that President Trump had provided to Ukraine compared to the support, or more accurately, lack thereof, that the prior administration had provided to Ukraine. In February 2004, Russia began its military campaign against Ukraine. Against the advice and urgings of Congress and many in his own administration, President Obama refused then and throughout the remainder of his presidency to provide lethal assistance to Ukraine. In the House, Manager Schiff joined many of his colleagues in a letter-writing campaign to President Obama urging that, quote, the U.S. must supply Ukraine with the means to defend itself, close quote, against Russian aggression, and urging President Obama to quickly approve additional efforts to support Ukraine's efforts to defend its sovereign territory, including the transfer of lethal defense weapons to the Ukraine military. On March 23rd, the House of Representatives overwhelmingly passed a resolution urging President Obama to immediately exercise the authority by Congress to provide Ukraine with lethal defensive weapon system. The very next day, this Senate passed a unanimous resolution urging the President to prioritize and expedite the provision of defensive lethal and non-lethal military assistance to Ukraine, consistent with United States national interest and policies. As one senator here stated in March 2015, providing non-lethal equipment like night vision goggles is all well and good, but giving the Ukrainians the ability to see the Russians coming, but not the ability to stop them, is not the answer. Yet, President Obama refused. He refused even in the face of support by senior career professionals, recommending he provide lethal weapons to the Ukrainians. By contrast, what did President Solinsky and the Russians know? They knew that President Trump did provide that support. That clearly was the most material thing to him, much more than important than a meeting in the Oval Office. The House managers also make much of their contention that President Trump supposedly wanted President Solinsky only to announce an investigation, not conduct anything. But that contention makes no sense. President Trump's call with President Solinsky was in July of 2019, almost a year and a half before our next election. Would only a bare announcement so far in advance with no follow-up really have had any effect on the election as the managers claim? Would anyone have remembered the announcement a year or more later? Ironically, it is the House managers who have put Burisma and its connection to the Bidens front and center in this proceeding. And now the voters will know about it and probably will remember it. Be careful what you wish for. Manager Schiff, well, there he goes again. He's putting words in the president's mouth that were never there. Again, look at the transcript of the July call. President Trump never asked about any announcement of any type of investigation. And President Solinsky tells President Trump, quote, I guarantee as the president of Ukraine that all the investigations will be done openly and candidly. That I can assure you. What happened next? The House managers say President Solinsky did not want to get mixed up in U.S. politics. But it is precisely the Democrats who politicize the issue. Last August, they began circling the wagons trying to protect Vice President Biden, and they're still doing it in these proceedings. They contend that any investigation into the millions of dollars of payments by a corrupt Ukraine company owned by a corrupt Ukraine oligarch to the son of the second highest office holder in our land, who was supposed to be in charge of fighting corruption in Ukraine, they're calling that type of inquiry a sham, debunked. But there has never been an investigation. So how could it be a sham? Simply because the House managers say so? Which brings me to yet another one of the House managers' baseless contentions, that President Trump raised the matter with President Solinsky because Vice President Biden had just announced his candidacy for president. But of course, it was far from a secret that Vice President Biden was planning to run. What had in fact changed? First, President Solinsky had been elected in April on an anti-corruption platform. In July, running on the same platform, his party took control of the Ukrainian parliament. That made it the opportune time to raise the issue, because finally there was a receptive government in Ukraine committing to fighting precisely the kind of highly questionable conduct displayed by Burisma in its payments to Hunter Biden and his partner, just as Joe Biden had raised years before. Two other things. In late June, ABC News ran a story entitled, "Hunter Biden's Foreign Deals: Did Joe Biden's Son Profit Off of His Father's Position as Vice President?" And then, just a couple of weeks before President Trump's telephone call with President Solinsky, the New Yorker magazine, not exactly a supporter of President Trump, ran an expose. Will Hunter Biden jeopardize his father's campaign? Going through some of the facts that we do know about Hunter Biden's involvement with Burisma and his involvement with a Chinese company. The New York reporter, again, this was in July, just a couple of weeks before the phone call, said that some of Vice President Biden's advisors were worried that Hunter would expose the vice president to criticism. A former senior White House aide told the New Yorker reporter that Hunter's behavior invited questions about whether he was, quote, leveraging access for his benefit, close quote. The reporter wrote that when I asked members of Biden's staff whether they did raise their concern with the vice president, several of them said they had been too intimidated to do so. Everyone who works for him has been screamed at, a former advisor told the reporter. I don't know whether anyone has been intimidated by Vice President Biden or has been screamed at by him about Burisma or his son's involvement. Do we want the type of government where questions about facially suspect conduct are suppressed or dismissed as illegitimate because someone is intimidating or screams at or is just too important? No, that is precisely when an investigation is most important. Now, last Thursday night, Manager Jeffries provided us with the Democrat standard for abuse of power. He said, quote, abuse of power occurs when the president exercises his official power to obtain a corrupt personal benefit while ignoring or injuring the national interest. Mr. Jeffries and the House managers contend that under this standard, President Trump has committed an impeachable offense and must be immediately removed from office. But if Manager Jeffries' standard applies, then where were these same Democrats' calls for impeachment when uncontroverted smoking gun evidence emerged that President Obama had violated their standard? The American people understand this basic notion as equal justice under the law. It is American as apple pie. Yet the House managers want to apply their own version of selective justice here, which applies only to their political opponents. They want one system of justice for Democrats and another system of justice for everyone else. But you do not need to take my word for it. Let's walk through the facts. On March 26, 2012, on the eve of the 2012 Nuclear Security Summit in Seoul, South Korea, President Obama met with Russian President Dmitry Medvedev to discuss one of the pressing issues in the United States' national security interest, military defense. How important was the issue of missile defense to the strategic relationship between the U.S. and Russia? As President Obama's Defense Secretary Robert Gates said in June 2010, upgraded missile interceptors in development, quote, would give us the ability to protect our troops, our bases, our facilities, and our allies in Europe. Gates continued, there is nothing of the minds on missile defense. There is no meeting of the minds on missile defense. The Russians hate it. They've hated it since the late 1960s. They will always hate it, mostly because we'll build it and they won't. During the Nuclear Security Summit, President Obama had a private exchange with Russian President Medvedev that was picked up on a hot microphone.
Last election, yeah. After my election, I have more flexibility. Yeah. I understand. I transmit this information to Vladimir and Medvedev.
President Obama said on all these issues, but particularly missile defense, this can be solved, but it's important for him to give me space. President Medvedev responded, yeah, I understand your message about space. Space for you. President Obama, this is my last election. After my election, I will have more flexibility. President Medvedev responds, I understand. I will transmit this information to Vladimir. As we all know, it's Vladimir Putin. As you just saw in 2012, President Obama asked the Russians for space until after the upcoming 2012 election, after which he would have more flexibility. Now let me apply Mr. Jeffries and the House manager's three-part test for abuse of power. 1, the President exercises his official power. President Obama's actions clearly meet the test for exercising official power because in his role as head of state during a nuclear security summit, after asking President Medvedev for space, he promised him that, quote, missile defense can be solved. What else could that mean but solved in a way favorable to the Russians, who were dead set against the expansion of a U.S. missile defense system in Europe? 2, to obtain a corrupt personal benefit. President Obama's actions were clearly for his own corrupt personal benefit because he was asking an adversary for space, for the express purpose of furthering his own election chances. Again, President Obama said, this is my last election. After my election, I have more flexibility. President Obama knew the importance of missile defense in Europe, but decided to use that as a bargaining chip with the Russians to further his own election chances in 2012. 3, while ignoring or injuring our national interest. As President Obama's defense secretary said, missiles would give us the ability to protect our troops, our bases, our facilities, and our allies in Europe. Surely, sacrificing the ability to protect our troops and our allies would injure the national interest. Yet President Obama was willing to barter away the safety of our troops and the safety of our allies in exchange for space in the upcoming election. In short, President Obama leveraged the power of his office to the detriment of U.S. policy on missile defense in order to influence the 2012 election, solely to his advantage. And we never would have known had President Obama realized that the microphone was on, that there was a hot mic. One could easily substitute President Obama's 2000 exchange with President Medvedev into Article 1 of the House's impeachment articles against President Trump. Using the powers of his high office, President Obama solicited interference of a foreign government, Russia, in the 2012 United States presidential election. He did so through a scheme or course of conduct that included soliciting the government of Russia to give him space, quote unquote, on missile defense that would benefit his reelection and influence the 2012 United States presidential election to his advantage. In doing so, President Obama used the powers of the presidency in a manner that compromised the national security of the United States and undermined the integrity of the United States democratic process. He thus ignored and injured the interests of the nation." Close quote. Does it sound familiar, House managers? It should, as the case against President Obama would have been far stronger than the allegations against President Trump. President Obama's abuse of power to benefit his own political interests was there and is here now for everyone to hear. It was a direct, unquestionable quid pro quo. No mind reading was needed there. Where were the House managers then? And that points out the absurdity of the House managers' case against President Trump. It was President Obama, not President Trump, who was weak on Russia and weak on support to Ukraine. President Obama caved to Russia and Putin on missile defense when he decided to scrap the U.S. plans to install missile bases in Poland, yet he criticized Senator Romney during the 2012 presidential campaign when Senator Romney said Russia was the greatest geopolitical threat to the U.S.
Governor Romney, I'm glad that you recognize that al-Qaeda is a threat, because a few months ago, when you were asked what's the biggest geopolitical threat facing America, you said Russia. Not al-Qaeda, you said Russia. And the 1980s are now calling to ask for their foreign policy back, because the Cold War has been over for 20 years.
Now, when it is politically convenient, the Democrats are saying the same thing that President Obama criticized Senator Romney for saying. In fact, they're basing their entire politicized impeachment on this inversion of reality. This claim that President Trump is not supporting Ukraine far more than the prior administration. President Obama caved on missile defense in late 2009. His hot mic moment occurred in March 2012. His re-election was 8 months later. 2 years later, in March 2014, Russia invaded Ukraine and annexed Crimea. President Trump refused to provide lethal aid to Ukraine to enable it, President Obama refused to provide lethal aid to Ukraine to enable it to defend itself. Where were the House managers then? The House managers would have the American people believe that there is a threat, an imminent threat to the national security of our country, for which the President must be removed immediately from the highest office in the land. Because what? Because he had a phone call with a foreign leader and discussed corruption, because he paused for a short period of time giving away our tax dollars to a foreign country? That is their theory. It is absurd on its face. Not one American life was in jeopardy or lost by the short delay, and they know it. And how do we know that they know it? Because they went on vacation after they adopted the articles of impeachment. They did not cancel their recess. They did not rush back to deliver the articles of impeachment to the Senate because of this supposed terrible, imminent threat to our national security. What did they do?
The urgency. The timing is really driven by the urgency.
Urgency.
Nothing could be more urgent.
The urgency.
And urgent. And urgent.
There's an urgency, to this.
And we must move swiftly.
We don't have time to screw around.
It's about urgency.
House Speaker Nancy Pelosi is still holding on to the articles of impeachment.
Urgency? Urgency for which you want to immediately remove the President of the United States? You sat on the articles for a month, the longest delay in the history of our country. They adopted them on Friday, December 13th, 2019, Friday the 13th, went on vacation, and finally decided after one of their Democratic presidential debates had finished, and after the BCS football championship game, that it was time to deliver them. What happened to their national security interest argument? Wasn't that the reason that they said they had to rush to vote? It's urgent, they told us. No due process for this president. It is a crisis of monumental proportion. Our national security is at risk every additional day that he's in office, they tell us. The House managers also used the same excuse for not issuing subpoenas for testimony. They had no time for the normal judicial review. They even complain about the judicial review process sitting in this chamber before the Chief Justice of the United States Supreme Court. A judicial review in which the judge agreed to an expedited schedule. Even that was not good enough for them when they issued the subpoenas. One of the lawyers for the subpoenaed witnesses wrote to the House General Counsel, quote, "We are dismayed that the House committees have chosen not to join us in seeking resolution from the judicial branch of this momentous constitutional question as expeditiously as possible." He continued, "It is important to get a definitive judgment from the judicial branch, determining their constitutional duty in the face of conflicting demands of the legislative and executive branches." Isn't that the point? Isn't that how our system of government works? Isn't that how it's always worked? Isn't that how it's supposed to work? These same Democrats defended other administrations who fought judicial review of congressional subpoenas. And I think we all remember Fast and Furious. The same attorney, when he wrote to the House chairs, said, "The House chairman, Mr. Schiff and Mr. Nadler, are mistaken to say the lawsuit is intended to delay or otherwise obstruct the committee's vital investigatory work." He continued, "Nor has this lawsuit been coordinated in any way with the White House, any more than it has been coordinated with the House of Representatives. If the House chooses not to pursue through subpoena testimony, let the record be clear, that is the House's decision. Yet they come before you and they blame the administration and they blame you if you don't subpoena witnesses and have them before you. Yet even in the face of this overwhelming evidence, they claim that the president is to blame for their decision to withdraw their own subpoenas or not issue others. Their choice, but the president is responsible. That is one of their claims. It is ludicrous. They are blaming the president because they decided on their own not to seek judicial review and enforcement of their own subpoenas, and for some witnesses never to even issue subpoenas. In their minds, that is impeachable. Manager Nadler spoke eloquently back before the House Judiciary Committee hearing in December of 1998. He said, quote, "There must never be a narrowly voted impeachment or an impeachment substantially supported by one of our major political parties and largely opposed by the other. Such an impeachment would lack legitimacy, would produce divisiveness and bitterness in our politics for years to come, and will call into question the very legitimacy of our political institutions." Manager Nadler was right then, and it is equally true today. Divisiveness and bitterness. Divisiveness and bitterness. Listen to his words. Impeachments by one party cause divisiveness and bitterness in our country. That is what a partisan impeachment leads to. Sadly, while Manager Nadler eloquently warned against divisiveness and bitterness, the House did not follow his admonition. They did not heed his advice. And that is one of the reasons we are sitting here today with articles of impeachment that are not founded in our Constitution or the evidence and are brought simply for partisan politics. This is a sad time for all of us. This is not a time to give out souvenirs, the pens used to sign the articles of impeachment, trying to improperly impeach our country's representative to the world. This is not the time to try to get digs in that the president will always be impeached because we had the majority and we could do it to you and we did it to you. It is wrong. It is not what the American people deserve or want. Sadly, the House managers do not trust their fellow Americans to choose their own president. They do not think that they can legitimately win an election against President Trump, so they need to rush to impeach him immediately. That is what they have continually told the American people. And that is a shame. We, on the other hand, trust our fellow Americans to choose their president. Choose your candidate. Let senators that are here who are trying to become the Democratic nominee try to win that election, and let the American people choose. Maybe they're concerned that the American people like his...
And you've been watching President Trump's legal team lay out their opening statements in day 6 of the Senate impeachment trial. They're building the case that Ukraine did not know military aid was being withheld, implying there could effectively be no quid pro quo, and the president did more than previous administrations to provide aid to Ukraine. Trump's lawyers outlining the issue of Hunter Biden's involvement on the board of Burisma, while accusing Democrats of exaggerating Rudy Giuliani's role in the Ukraine affair. The trial is now about to take a dinner break. We're going to return you to local programming. Please stay tuned to Fox News Channel and this Fox station for continuing coverage. I'm Laura Ingle in New York.
This has been a Fox News special presentation.